Welcome to The Legacy Cast by Kelley Legacy Law.
Hey everybody, welcome to an all-new episode of The Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. I'm your host, Mike Leon. You know, Mike's practice here focuses on helping families enhance their lives today and secure their future tomorrow. And in today's episode, we're going to be talking about why a will doesn't keep you out of probate and how a living trust can help you. So Mike, good to see you. Let's talk a little bit about this because I think a lot of people assume that having a will means their family can skip probate. Why isn't that the case?
Yeah. First off, thanks for having me today. I love educating the population about these issues. So, one of the first things that we do need to make clear is, that a will certainly doesn't skip probate. I'm in the state of Alabama, and as long as you have assets in your name when you die, then you're using that last will and testament to make sure that the assets get to the people that you've chosen when you put them in the document. So I think a lot of people think that you might skip probate when you have a will simply because that's what they see in movies. In the movies, they show the family getting together in the library with the mahogany books and the furniture, and the attorney is there reading the will. And then everybody fights about who is supposed to get what. And then that's end of scene, right? They don't show it, the next part where everybody has to go to the courthouse and file the will and go through that probate process. So I think, honestly, it's just a matter of people, you don't know what you don't know. And nobody ever in the movies and shows, nobody ever talks about the actual court process unless they know someone who's been through it that's kind of warning them about what it's like.
Let's talk about potentially staying out of the court process, which would be with a living trust, or you can explain if that's true. How does a living trust work to keep families out of the court compared to a will?
Yeah, there are ways to avoid probate without a trust. There are ways you can structure assets. For example, some people try joint ownership of bank accounts, joint ownership of real estate, beneficiary designations on life insurance and retirement accounts and things like that. Those are kind of ways that you can try to piecemeal your way around probate. Then you have a last will and testament that ends up not controlling anything because there's nothing to go into the probate court. So you may have a will that says everything goes equally to my 3 children, but you've got your daughter on your bank account with you as a joint right with survivorship, and you've got them on the deed with you. You've got them on the deed. Well, when you die, that property automatically belongs to that child, and they can decide if they want to give some to their siblings or not. And so that's a misconception. But a living trust is really the most foolproof way to avoid probate court, because what happens is we transfer assets from ourselves as individuals to ourselves, typically in a living trust scenario we're talking about here, to ourselves as trustees of our living trust. So it's a kind of a matter of semantics, but it's this legal creation we've come up with to get assets out of our names, so that when we pass away, there is no asset to go into the probate court because we don't own anything. So that is one of the primary reasons people use the living trust, is just to avoid the probate process by getting the assets in the name of a trustee who can handle those things.
When you explain probate to clients, I'm curious, what are some of the things that surprise them the most about probate court? Is it just how long or how expensive it could be?
That's some of it. A lot of it too is, in fact, for example, every state's different, but in Alabama, once a will is admitted to probate, or if you don't have a will and you just have to have someone open an estate for you, it's called intestacy here. When the minute somebody is appointed by the judge to be either the executor or the administrator, there's a 6-month window that opens where the testator's assets, or the deceased person, the decedent's assets, are essentially frozen for 6 months. So they have that in place so that creditors have an opportunity to find out this person died and file a claim in the probate court case. Okay. Well, the family suffers from this because they really can't use the assets for 6 months while they wait to see who's going to step forward to claim these assets. At the end of that 6-month period, then we deal with creditors. We pay the ones that are valid, dispute the ones that aren't valid. Then we deal with the IRS. Okay. Sometimes we have to wait a few months for the new tax forms to come out before we can file the tax returns for the person that died and the estate. So, we're looking at 12 to 18 months on average. I think the thing that surprises a lot of people, though, is just some of the nuts and bolts. If you die without a will and your estate has to be probated, you got a lot of hoops to jump through. Okay. You've got to get a probate bond, which is an insurance policy to cover the value of the assets of the estate. You have to file a petition that lists not only who is set to receive your assets, who's your next of kin, but how old are they, where do they live, their names. So anybody in the world can look into the public record, which it's all public, everything we file, and they can see who's going to receive money from this person. And our administrator also has to file a very detailed inventory of assets in the probate court case. Now, of course, that's to benefit the creditors again. They can look and see, okay, can I collect from this person's estate this debt that I have? But again, other people can see that. Creditors of your heirs may see that. Maybe there's a judgment creditor that your child's going to receive some money. Potential divorce situation could come up where, ex-spouse, future ex-spouse may hang in there a little longer until you receive your inheritance, and then they take some of it. So I think the length of time and expense obviously is something that people don't have the details on, and they certainly don't like. But then when we talk about some of the procedural things that you have to do, they're not crazy about that either.
Mike, the nuts and bolts part of this that you just mentioned, I think one nut and bolt that they're forgetting is the emotional stress that this can cause a lot of families. In your experience, what are some of those emotional stresses that families face, especially when they're going through this probate process and they just lost a loved one?
Yeah, this goes all the way back to my very first lesson, I guess I would say I learned when I started helping people probate estates and draft estate plans. Okay. Couple came in to see me, and the gentleman, it was a married couple, he had cancer, and they were doing planning because they knew he was not going to defeat this. And so we do, last will and testament for each of them. We name each of them the executor for the other. That's the standard way most married couples do it. Husband dies, wife will be executor, vice versa. So we did it that way. And about 6 months later, he passed away, and his wife came back to me. We filed the documents, the will and the petition, everything you've got to file in the court to get her appointed as executor. And then a little bit of time went by, and it was probably a couple of months. She called me, and she was so mad at me. I mean, she was angry at me. Why can't you make these creditors stop calling me? Why can't you do, I said, ma'am, that's your job. Like, this is a job. Okay. You have to protect the assets of the person that died that are in the probate court. All right. You have to talk with the creditors and keep them updated on what's happening in the estate and can they expect to be paid. Right. She was grieving. Okay. She was upset. And when we're in that state, a lot of times we just don't want to deal with anything. We don't want to deal with that stuff. Okay. And so I tell people now when we go through estate planning, think of your executor and understand that it's a job. And as soon as the person dies, you have work to do. It's not an honorary title like the Queen of England. Okay. It is, it's a job, and you have to be prepared. So the emotional stress of that just in and of itself, having to deal with it after the death of a loved one. But then, also not having access maybe to assets that you need. The probate courts in Alabama, the laws, there are certain exemptions for a certain amount of money that a surviving spouse or children can access immediately. But it's a very small amount potentially compared to the entire amount of the assets. So a lot of times there may be a struggle there for that 6-month period while we wait for creditors to get taken care of and then the rest of the money to be released. So that can cause a lot of stress too.
Mike, I would love for you to kind of explain a little bit for our audience the difference between having a will versus having a trust, and vice versa for each of them, like the benefits and situations potentially where you've advised clients on either or, and which one would be the right choice for them.
Well, I tell you what I do. I lay out all the potential outcomes for my clients when they come in, and I let them choose really what they want to do. So I don't really tell people what I think they should do unless they just come right out and ask me. We find out, our process is we're going to find out before our clients ever come in everything we can about their family structure, their assets, and their goals and their beliefs. Okay. So we send out a questionnaire that they're going to fill out before they ever come in. So when they sit down with us, we hit the ground running. Now I will say, if I'm meeting with someone who's really young, maybe they don't have a lot of assets, but maybe they've got young children and they want to make sure that, okay, whatever they do have will ultimately get to their children, and maybe even set up some kind of what we call a testamentary trust inside of a last will and testament so that if they die, instead of their minor children receiving, a lump sum of money that some, conservator is going to be in charge of, they can name a trustee to hold that money on behalf of the kids and spend it for their benefit. But, alternatively, maybe it's someone that, as far as a will goes, it's someone, maybe they're elderly and maybe they just have their house and a couple of bank accounts, not a massive estate. And honestly, most of the time when we do will plans for people, we still say, okay, how can we avoid probate with the assets you have, so that the will is really kind of a safety net instead of the central plan. So we may look at an elderly person and say, hey, can we do what's called a life estate deed, where you can go ahead and deed your house to your kids, reserving the right to live there. So when you die, it automatically passes to them. Can we do a transfer on death benefit, a designation with a bank account, so that your child can just go claim that money when you die and it doesn't go through probate? So honestly, for us, will plans are for people that maybe they don't have a lot of assets, but we want to make sure that, hey, we can still try to avoid probate with the assets you have and use the will as a backstop, just in case. Now, the living trust, a lot of people ask me, well, do I have enough money for a living? Would that make sense for me based on the net worth that I have? I tell people it's not always about your net worth. Sometimes it's about the outcome that you want to achieve. All right. I've got people that have come in and said, hey, I know I don't have a fortune, but I've got a piece of land and I've got a house on it. My elderly parents live with me. So I want to make sure that if I die, my elderly parents can continue to live in the house. And then when they die, I want it to go to my daughter. Okay. Well, if they left their house to their parents in a last will and testament when they died, well, then their parents' will cover where it goes. So it could end up, in this case, it would ended up going to this person's brother, okay, instead of his daughter. Well, we put it in a trust, okay, so that when he dies, it stays in a continuing trust. His parents continue to live there, called a personal occupancy trust, okay. And then when they die, or if they leave the premises, it automatically goes to the daughter, okay. So that's an outcome that he wanted, not necessarily based on him being mega wealthy or anything like that. So the living trust really is for three purposes. One is probate avoidance, which we've talked about. Okay. Two are for people that want to do some tax planning, whether it's inheritance tax planning or capital gains tax planning. And three, some people want to give asset protection to their children as well. So when the second person dies, if it's a married couple or if it's an individual with a trust, they can do some things, after their death to protect the assets that they're leaving for the next generation. So I would say that's the two differences.
Mike, I want to expand on something you just mentioned there. And it's really around, let's say, blended families or even families that have, let's say, a bunch of complex assets. Can you kind of explain what those complex assets could look like? And how does a trust provide more peace of mind, or does it provide more peace of mind in that scenario?
I get a lot of clients that come in and they have a net worth between 1 million and 15 million, and they've got their home, and then they've got a second home, and maybe they have rental properties, maybe they've got a business that they own, and then they've got retirement accounts, they got life insurance, they've got an annuity. All right, they've got all these different things going on, and all of them have different tax implications associated with them based on if it's a retirement account, based on the Secure Act. Should I leave it to my spouse? Should I leave it to a trust? Should I leave it to a charity? With second homes, how do I make sure that we take care of that? But when a blended family situation, okay, we have issues with the fact that most of the time we're going to have children from previous marriages. All right. So this blended family comes together. Now we're going to have what I call stepmama drama, potentially. Okay. Because, we have a situation a lot of the time where, let's say, husband puts, in a document, let's say he wants to use the last will and testament. He wants to say, okay, when I die, I want the lake house to go to stepmom. And when stepmom dies, she has to give it to my children from the first marriage. I tell people, hey, in a last will and testament, that's not going to work. Because if you leave it to her, it is going to be hers. And she will be able to then turn around and amend her estate plan or whatever she wants to do and leave that to her children. That's when we talk about people accidentally disinheriting their children, that's what we're talking about. Okay. Not realizing you can't really continue to put conditions on property after you've already given it to someone outright in a last will and testament. Okay. So what a trust can allow us to do is, let's say that, first of all, let's say that it's a situation where it's a blended family, but there's clearly property, whether it's real estate or bank accounts, what have you, that are going to be considered to be separate property. So some is husband, some is wife. Okay. And maybe they want to make sure that whatever their separate property is ends up with their children only at the end of the day. But they want their spouse to be able to continue to benefit from them if they die first, right? So in that case, we can do separate trusts. We can do one trust for each individual, okay? And the husband's trust may own some property. The wife's trust may own other property. And then those two trusts may own property together. Let's say the marital residence. Maybe each of their trust owns one half of that property. Well, first person to die, they can basically say, okay, it's going to stay in continuing trust for my surviving spouse, who gets to still be the trustee over this and continue to use it the way they always have. But when they die, what's left in my trust will then go to my children, period, end of story. So that's a way they can make sure their children are going to receive something from them, even if they die first. Okay. Now, that's a separate trust scenario. But we can do what's called a joint marital trust as well, where we do one document, one document that will allow us to put these protections in, and it doesn't really matter who passes away first. Okay, so simply put, what happens is first spouse that dies, their separate property, which is anything we've considered separate property when we've set this up, and half of any of the joint property that they consider to be owned by both spouses, can be put aside in an irrevocable trust or two, depending on what kind of assets we have. That's always going to be there for the surviving spouse to continue to use, but when they die, it will go to the children. Okay. The surviving spouse's share at the first spouse's death stays with them in a continuing revocable trust. I know we're getting off in the weeds here, but they continue to use it however they want to. They can amend it, restate it, do away with it, whatever they want. So they've got their share to continue to do whatever they want to with. The decedent's share is held safely in irrevocable trust that ultimately will go down to their kids. So that is a way we can make sure that in a blended family, we don't disinherit our children. Okay. And it allows us to do some other things with tax planning as well, whether it's capital gains tax, inheritance tax planning.
So, Mike, someone's listening to this right now. They haven't done any planning whatsoever. What's the very first step that they should take today to keep their family potentially out of probate court?
Well, I would congratulate them, because this really is step one, is beginning to be educated about these things. There's a lot of information out there right now that we've never had access to before. People are using AI, Chat GPT, Grok, what have you, to ask a lot of these questions. And those are great tools, but you also have to be very careful, because they will give you incorrect information. And it's easy to get off in the weeds if you're doing a lot of research yourself, because there's so many different kinds of trusts. What's the difference between a living revocable trust and an irrevocable trust and a Medicaid trust and a special needs trust and a charitable remainder trust and a SLAT and a CRAT? There's a lot of different trusts out there for different purposes. So my recommendation is always going to be seek out, legal counsel. Now, depending on where you are, you may seek out something like what I do, which is I do a lot of seminars, live seminars, and I do webinars as well. But I really have a passion for trying to educate the public on these issues, because I have seen just too many broken families and things end up in the probate court for years, arguments happening over things that were so easily avoidable had the parents just put it in writing. Right. And not including, and that's healthcare issues too, not just assets. We talk about money and assets and how to pass those things, but choosing the people that can make healthcare decisions for you, if you can't for yourself, is a massive thing to do too. So.
Yeah. Thank you, Mike, for the time and insights on this, man. We truly appreciate it.
Thank you so much for having me. I enjoyed it.
And thank you to everybody out there for tuning in to another episode of the Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. If you want to connect with Mike and the team right now, do me a favor, visit kelleylegacylaw.com. And don't forget to like, subscribe, leave us a review and comment, or share this episode with somebody who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.